Hey guys, I'm back. I'm waiting for my girl and my son to come on in. Where they at? Where they at? Where they at? She's putting my what's the name on y'all? She's putting my what do you call that thing? Watermark. She's putting my watermark on my stuff. Hey honey, you back? Hey Kayla, you're here, you're here, you're here. She's getting she's putting my what's the name on? Thank you. We're gonna put this up here too. So yeah, I even tell them. Can I get the likes up now? Can I get the likes up before we get started? Can I get the likes up? Get the likes. Go out, guys. Come back and hit the likes. Make sure, moderator, make sure they hit the like. Hit the likes. Hey, Olga, where you been? Oh my God, I haven't seen you in a while. Hey, Olga. Where have you been, young lady? You know who I'm looking for? I'm looking for Jan. Jan hasn't been in here in a while, too. I see Jana. Jana's the one gonna get her butt beat. All right, Jana's putting a little clip in here. She said that thank you, Carolyn. Thank you, Jana. Thank you, Tiara. Tyria. I keep messing up your name, you know that. Patrick is in the house. Hey, Patrick. Your wife is listening. Hi, Patrick, wife. How are you? How you doing, Patrick, wife? It's nice to meet you. Please like and share, please. Hey, Tawana. Hey, Ruby. Thank you, guys. Go out, hit the like, because you know I'm going to have an attitude if you don't hit the like, because, you know, I'm an attitude person. I'm still PMSing, okay? I'm still PMSing. Come on, son. Son, look at your email. I'll send it to you. We're spitting fire. She got it, too. Where's she at? I sent it to my son. I sent it to... Hey, Valerie, only 42 likes and 62 people in the chat. Okay, there's 20 of y'all just being very, very fuddy-duddy. Tanya, did you hit the like? Dom, you got it?
Yep, I got it.
Okay. I'm waiting for Randa to come. I'm waiting for Randa to come with the
Where are you at, Randa?
She's doing my what's the name? Watermark. I talked to her already. She's doing my watermark. Oh yeah, y'all ready for it? Y'all ready for it?
Well, I mean, you don't have to watermark. I mean, you can just. What I'm saying is, you don't have to show it, but it's.
Are you gonna read it without showing it? Can they hear you?
Yeah. Or I mean, it's up to you. We can wait till she watermarks it.
No, I mean, you can start reading it.
That's fine.
Read the first one. Read the first one, not the one of the number 2, just the first one. Thank you, guys. Get the likes up. Wait, hold on. Let them get the likes up.
Yeah, wait till they get the likes up first. Yeah, that's what we're gonna do. We need 100 likes, and then I'll read. Until we got 100 likes.
Hey, dude, we ain't got 100 people in here.
Hey, it'll be. You just had 150. So when we left, so they'll come back.
Randa is the bomb. Look at how she got it, girlfriend. I love my Randa. She's so fast with this stuff. She be getting it in.
And this is why Mr. Bozo misses you and Randa both.
Yeah, I think so too. Because Randa be on it. Daggone it. Okay, where's the other one? I see the number 2. I don't see number 1, Rand. Where's number 1 go? Oh, there it is. I found it. All right. Here we go. Randa's the bomb. Diggity bomb. Where's she at? She ain't trying to come in.
Randa, hit the link.
Hit the link, Randa. Hit the link. How many likes we got?
How many likes we got? We need 100. I don't care. 100. We just had 145 in the chat right when she ended, like 30 seconds ago.
Thank
so we
you.
need 100.
We got Facebook hit a likes. A Facebook person hit a like. Thank you, guys.
Yeah, we need it. That's the least.
Come on, Dom gonna sit over there about where the hell you at?
Yep. You do it to me.
Bothering me about something, so you just gonna set me up.
You do it to me, so I'm gonna
Rand,
do it
after
to
you
your
gonna get the thing to read it.
No.
I'm gonna let
Dom likes to read.
Because apparently nobody wants the woman to read it.
I don't like. Should be. According to the document, Mr. Kelly.
The John does.
That's how I be reading. That's how the little lady reads.
Let her damn read.
Shoot, hell no. I want to hear. Have you guys ever heard Bozo?
You be trying to mess up on your words.
No, I've never heard Bozo read. I don't think.
No, he read, but he be fucking up some shit too. That's why I be like, yo, what the fuck are these motherfuckers? He fucking up with that. He stuttered when he read.
We had 79 likes. We need 21 more likes, and I'll start. 21, y'all. The government has replied. The government has officially replied to the defense. Damn it. Come on, y'all. Get the likes up.
And Dom's going to read it all.
Because it ain't 56 pages like he did the last time.
Potentially. Perhaps.
Oh, we got 91 people in the chat. Come on, y'all.
Come on, y'all. We almost there. Hold on. Let me see how many we got now.
Hit the likes, y'all. Hit the likes.
82.
Thank you, Valerie, keeping the numbers.
18 more, y'all. Let's get them up. Get your backup page, your mama, your granny, your uncle, your son, your niece, your grandbaby, all of them like it. Come on, y'all. You're almost there, y'all. What's up, 313? Where you been at?
Look, I've been still trying to get the super chat in there. Thank you for the super chat earlier. Thank you. Who was it that gave me a super chat?
It was Miss Texas. She gave you 50.
Thank you, Miss Texas. I appreciate you, darling. Miss Texas get highlighted today. Hold on, we're gonna highlight the person that did the cash chat. I mean the super chat. Thank you, Miss Texas. Woo woo, Miss Texas in the house. Woo woo, woo woo. Hey, none of that music. Stop.
My bad. My phone was ringing. Brand new whip, got no keys. Tell them no starts, please. Got M's in the bank. Like, yes, indeed. Randa, I need 1 million, please. Hey.
A million. But see, I would play, but still ain't gonna play that.
Where was 313 at?
We trying to get this is a monetized.
I know. I said I said I'm not gonna do it.
Where was 313 at?
What you doing?
He just popped up. Where you been at, bro? You been at work?
Had. It's 313 be in the cut, y'all just do. He be the
108. We have 108 in the chat and 90 likes. We need 10 more likes.
Let's get it up.
10 more likes, y'all. Come on. She spent her money for this. Even Sharon Wincap hit the like. Even
the
Bozo.
The dead flyer.
Yes. Get them likes up, Bozo.
Hey,
but why?
Flower lady, get the likes up.
Get the likes up. Why Bozo be having more dislikes than likes?
Thank you, Factory Diggins.
Oh yeah, that's
for the super chat.
Well, thank you, Valerie.
What's up, Trevor?
Go, Valerie. Okay, Valerie, get highlighted, y'all.
I do not got your damn phone tapped. 313.
Get highlighted. Come on, all the super chat folks get highlighted because that's what we're gonna stop praising those people that do the super chat. You know what I mean? Like, ooh,
brand new whip, got no key. Right? What's good, Trevor?
Ooh. How many?
I ain't scared of you, motherfucker. I ain't scared of you, motherfucker.
How many likes do we got?
99 likes. We need one more.
We need one more. Come on, y'all.
One more, y'all. Come on.
Get that 100.
Hey.
What happened, Randa?
No, I'm talking about my phone acting crazy.
We got 119 in the chat. Nope. Now we need 110. No, I'm playing.
Don't be on some BS.
Stop acting like
Hey,
you a crack.
You know,
I'm
put a nigga in
telling
the
you.
chat so 313 can bring his butt up here and read.
Yeah, let's hear you read 313.
Okay, I didn't get 313. Give
Let
me
me
your
tell y'all
email.
something. 313 and click that link and say, y'all got me fucked up. I ain't reading.
Right. No,
You
what
know,
he gonna do is he
cuss
gonna
me out
say,
in a minute. He gonna
hey,
cuss
Randa, he
me
gonna
out.
say, what's
313.
good, Randa?
Send me your email. Email me your email so I can send you the document so you come in here and
He
read.
gonna say, Randa, he gonna say, what's good, Randa? What's up, Dom?
Come
What's
on,
up,
313.
Sylvia?
Come
And
on,
then he
man.
gonna
What's
go
up? And then he gonna put himself on mute because his phone
mute
gonna start
for the
acting up because
Oh,
of
next
yeah,
that
2
damn
yeah. You
hours.
gonna
T-Mobile.
mess us up.
No
Then
offense to
for the
anybody
next
else who got
2,
T-Mobile, but he got goddamn T-Mobile.
hey, for the
Look,
next 2 hours, he
I've
gonna
been
be
promised
muted.
he's gonna read because he's talking about his heavy accent.
Ivan be lying. Y'all know Ivan is a jokester.
Yeah, he do. 313 gonna be
Ivan's
gone for
so
3
damn
hours.
funny.
There you go. What's up, bro? What's poppin'?
313, send me your email.
And
So I
stop
can send it.
lying on me, 313.
Hey,
Man, you
Randa the
know I'm
Feds.
not lying. No,
But
she
Randa
you
the
not
a
the
Feds.
feds.
liar.
She not the feds, but her block hot, man.
My block
Her
is
block.
not motherfucking hot. You know, if my block is hot, you know why, right?
Bozo.
Thank you. Thank you, Don.
Bozo done tapped into her
got
phone.
me
God damn
hot
it.
and shit. You can't, man.
You
My
a
phone,
like you. That's you. That's you. You
my,
hot. Your
my
phone hot.
phone still been acting up.
We got 116 likes.
Hey, Randy, we got another item.
Here we
Hey, but
go.
Dom, you was on point. Or who said that? I was gonna say that, but I can't say
What you
that.
say, sis?
I can't say
I
that
thought
Say
it
on
was
this
what?
another
stuff.
item. Never mind.
Say what?
You said another item.
About the
Yeah.
reading. Who said that 313 gonna get on here and be like, y'all got me?
Oh, that
Randa
was
said
Randa.
that.
That was
Oh,
Randa. I said you just
you
go on mute for 2 hours.
Dang, y'all just snitches.
nah,
Nah,
look.
I
Y'all
ain't no
just
snitch.
Since I've been put on blast, I might as well go ahead and say it publicly. I did not mute for hours. If y'all don't hear me talking, I went to sleep on you.
Thank you. I was gonna say it. I sure the hell was gonna say it if you
I
didn't
know
say
you
it.
was gonna tell. You gonna
I'll
tell
let
it
y'all
all.
know right out the gate that 313, if he quiet and he don't get off mute, he's sleeping.
No, sometimes if I'm working or something though, I don't be sleep.
All right, y'all, I'm about to show the stuff now, y'all. Y'all ready?
Sylvia
Y'all
kicked
ready?
me
Get ready?
off for making noise.
Yeah, I'm about to start. Let me know
You
when.
acting up.
Dom gonna do all the reading. Go ahead.
Hold on. Oh, Spitfire's here to do the reading. Hold on, she here. She here. Hold
She
on.
saved the day,
There
Dom.
she
You
go.
ain't
There
wanna
she
leave
go,
it
y'all.
alone.
Why the hell I always come in at the
No,
wrong
I'll
damn
read.
time?
Hey, and you
What's up,
know
Spin?
you here now, so you gonna have to do the reading.
You better not go nowhere. You and Dom can't be to stay your asses on here.
No, I got you. I'll read it.
Now,
Y'all know I like reading.
Cause I know every time I come, y'all showing up, hit that lead studio real quick.
well, you know, my
Mr.
phone be
313,
down.
you too. You
My
stay over
phone
Hey,
be
here.
down.
hey, I ain't going nowhere.
Okay,
I
Okay, y'all
send
got
it
you.
to
ready?
me, Sylvia, so I
Okay.
can send it in I can pull it up on another screen.
I already sent. You want me to
Syl-
send it again?
Oh
Sylvia,
no, I
put it
didn't
up.
check it. I didn't know you sent it. Hold on,
I
let me
sent it
check
to you
it.
from the beginning, ma'am. I
Okay,
sent it
wait a minute.
because
No,
I
no,
sent it to
I
three
got it.
people.
I got it. Which one? Let me see. You sent me
Sylvia,
two
put it
stuff.
up.
Which?
Yeah, one is 151, one is 148.
So, Spitfire,
Okay.
I'll read the first one. You read the second one.
Dom, you read the 148.
Yeah, I read the
Which
first
one is
one.
that?
I read the first one.
Don't
Look at
play me,
the case
Spitfire.
number,
Don't do that.
the item number, the docket number is 148. One of y'all read 148, the
Sylvia,
other one
didn't
read
you have the
150.
little robot who
Spitfire,
used
don't
to
do that.
read?
Why? Why?
You gotta read document 2. You came late.
No,
That's the
shut up.
longer one.
No, you can read the longer one. You
Nope.
younger. You have a lot more
Hey,
energy
tell
than
Dom
me.
he got to read because yesterday he dipped out on you.
That's right. You dipped
Don't
out
play.
on me, so you got to
Hey,
read that.
what's wrong with the
I'm
little
reading the
computer
first. You
reading?
reading the second.
I know. I'm
Spitfire.
reading the first part. You reading the second part.
Nope.
All right,
Nope.
let's play.
Okay,
All right,
so
here we go. Put it up. Sylvia, put up.
Dear Judge Donnelly. Okay, we starting with Dear Judge Donnelly. The
A
government
reading
respectfully.
rainbow.
Y'all ready? Okay, Dear Judge Donnelly, the government
You,
respectfully submit
everybody
this.
except
Sylvia, put it up
Spitfire.
on the screen
Hold
so people can
on,
see it.
Dom.
Oh,
My
okay.
fault.
I can't see Sylvia right now because I'm on another screen.
It's okay. You can continue reading.
No, I
Ignore
want
Dom.
so
You
the
don't have
people
to
can
hear.
be able to follow me. So I'll wait for you.
Hold on. You 148, right?
No, I'm the first. I'm the beginning.
148. It should be docket number Document number 148. That's the
Mine
first one.
says docket number 12286. I don't see no 148.
Spin
No.
fire at the top. At the top.
the
It says
top.
case 119 and it says document 148 at the top in red. In
No,
red
that's
writing.
not what I have. A case 148. I don't have that. Okay,
Document
I'm just gonna tell
148.
y'all read page 1 through 8, damn it. Okay, where it says Dear Judge Donnelly, and that's the first part. Y'all don't know that's the first part. That's on y'all.
Sylvia, Randa, mute.
I'm
Randa.
gonna read Brandon's tail. I'm gonna mute her behind.
Sorry, I had to play that because y'all must acting like goddamn reading Rainbow up here.
Shut up, Randa.
No, do you see it though? Spin fire, which one do you see?
I see where it says to be filed under seal.
No, that's the wrong one.
Okay, hold on.
You probably looking at an old email.
Okay, it's I'm at another one.
Brandon,
I got the same thing.
Brandon, stop it.
I don't see it.
Okay. I got it.
Sylvia,
It's
what
cool.
did you send me?
Sylvia, okay,
You
here
sent
we
me
go.
the same thing twice.
No, I said just like I said that. You right there with them. If they got whatever they got is what you got.
This is thing.
Sylvia, I got you.
Okay, I got it. 148. Okay, I'm 148. Okay.
Don't be muting me.
I got 148. You ready? I didn't see it in the middle.
Can y'all put the rainbows in the chat?
Shut up, Randa. Okay, because you can still go get a switch. Okay, you still ain't got the switch. You got the last switch.
Randa the defiant kid.
Everybody
That
mute.
show is bad
Everybody mute
bud.
except spitting fire.
You ready?
Yeah, go ahead.
Okay, I'm not gonna read the honorable, all that kind of stuff in the regarding. I'm just gonna start with Judge Donnelly. Dear Judge Donnelly, the government writes to reply to the defendant's response in opposition to the government's motion in limine to admit other acts of evidence. Okay, I'm not going to read the case study or whatever. For the reasons set forth with herein and in the government's initial memorandum, the government motion should be granted. First all of the other acts evidence of government seeks to offer the admissible as directed evidence of the charged racketeering offense. A fact the defendant fails to mention in his response, therefore, the notice provision, okay, the rules of evidence does not apply. Okay, that's another case. In its initial memorandum, only as an alternate basis for admission of this evidence. So I guess they're citing some stuff. Significantly, that's where I'm at. You guys see where I'm at? Significantly, as set forth in the government's memorandum in support of its motion to admit certain other acts evidence, a racketeering offense is not limited to just the enumerated racketeering acts. Rather, it is a combination of both the activity of the enterprise and evidence of the pattern of racketeering, demonstrating that the defendant conduct is interrelated, and that there is continuously. This is messed up, Sylvia. A threat and continuously to offer through the presentation of charge and other acts.
Continuity.
Okay. Continuity or a threat to continuity and other. What's that word?
Often.
No, often through the what? It's missing
fire.
here.
Did you just smoke?
Is it?
No, I don't have it. Wait a minute. Hold on. Let me refresh. Let me refresh my screen because it's missing. It's missing characters. Hold on. That's why hold on.
Y'all keep putting them rainbows in the chat.
Shut up. I'm back red. Okay, now it's clear. I'm sorry. I had to refresh.
Guys,
let me start over.
Guys, apologize.
I had to refresh.
Spitfire just woke up.
I had to refresh. It wasn't coming through. Significantly, as set forth the government's memorandum in support of its motion to admit certain other acts of evidence. A racketeering offense is not limited to just the enumerated racketeering acts, rather than it is the combination of both the activities of the enterprise and the activities of the pattern of racketeering, demonstrating that the defendant's conduct is interrelated and there is a continuity and threats of
Oh my
continuity, often
goodness.
through the presentation of charge and other acts. Okay, it says, as clearly set forth in the government's memorandum, other acts of evidence, I'm down on the second paragraph, discussed therein falls squarely within the time frame of the charge racketeering activity in or about January 1994 and the present, and involves not only the defendant's own conduct, but his use and other reliance of various members of the charged enterprise to carry out the uncharged acts as part of the methods and means of other pattern of racketeering charge. In the case including, but not limiting to, selecting victims, making travel arrangements, and carrying out the defendant's instructions, where we were used to control the silence of his victims. The pre-offered evidence throughout therefore reflects not only the defendant's pattern of racketeering, but also the long-standing continuity in such conduct committed by the defendants and other members of the enterprise throughout the duration of the racketeering period. Second, even if the notice provision of Rule 404B did apply, the government has complied to those provisions. The court set the schedule to file motion in limine on February 9th, 2021, and at no time did the defense counsel seek an earlier date to file of the government's Rule 404B motion. The government was prepared to file its motion on Monday, July 19, 2021, but the defendant sought an extra 4 days for the filing of motion in limine, an extension to which the government did not object. Okay, regardless of the government notice was sufficient such that the defendant has a fair opportunity to meet it. Significantly, the defendant has had an ample notice of the government's evidence as substance in these uncharged acts, and evidence supporting them were disclosed in the government's production of 35 material, as well as the prior production Rule 16 discovery. There is also true of the allegation concerning John Doe 1 and John Doe 1 and John Doe 2. The government disclosed 35 material relating to both John Does on February 5th, 2021, as well as discovery material corroborating their claims. Thus, the defense had ample notice of allegations of sexual blank, okay, while the evidence of the government seeks to admit regarding the defendant's introduction of sexual conduct with Jane Doe number 1 includes evidence from approximately 1992 and 1993. Such evidence is admissible because it is direct evidence of racketeering act 1, okay, extricably intertwined with the conduct charge and the racketeering acts, and provides relevant and important background concerning the conduct. I think that's a case study. Do the parentheses. It is within the court's discretion to admit evidence of fact committed prior to the time charged in the indictment to prove the existence of the alleged conspiracy, as well as how its background and history. Okay, the other parentheses, not the case study. Other crimes or act of evidence admissible where it is arose out of the same transaction or series of transactions as charged offense. It is all extremely intertwined with the evidence regarding the charge offense, or it is necessary to complete the story of the criminal on trial. Okay. Let me see. I don't want to read that. Okay. Noting the evidence and other bad acts may be admitted, and to provide the jury with the complete story of the crimes charged and demonstrate the context of certain events relevant to the charge and offense. 2, the defense claims that there is never any mention by the government that the controversial topic sexual contact between the defendant John Doe and John Doe 2. I'm thinking that's supposed to mean John Doe 2. Activity between the defendant of John Doe 1 and John Doe 2 could have sought to have include a question regarding the allegations in the questionnaire. Moreover, jury selection is not completed, and should the defendant request, the court should pose additional relevant questions as the topic to during the jury selection process. I don't know what that word means. Nor there is any merit in the defendant's allegation that there is no evidence supporting sexual activity between the defendant of Jane Doe 1 while she was a minor. There is absolutely no physical proof nor circumstantial proof that any of these allegations put forth of the governments are true. Jane Doe number 1 is unable to testify that any of the above allegations are true. There are merely accusations and exist in forming the government's narrative. A witness, 1, will testify that the defendant admitted to him that based on the information that the defendant obtained from Jane Doe 1, the defendant believed that Jane Doe 1 was pregnant by him. In addition, witness 1 will testify that based on the defendant's statement and the demeanor, he believes that the defendant was an individual who impregnated Jane Doe number 1.
Too, a liar and a thief. They need to bring his background.
From reading?
Sorry.
Including because the defendant admitted that the defendant was advised that he could need to marry Jane Doe 1 to escape prosecution. Many of these admissions were made just before witness 1 helped the defendant arrange an unplanned flight to return to Chicago while the defendant was on tour in another state to secretly marry Jane Doe 1. In addition, another witness, Jane Doe number 7, will testify she saw the defendant engage in sexual contact with Jane Doe 1 in or about 1992 when Jane Doe 1 was just 13 years old. Jane Doe 5 also will testify that the defendant admitted to her that he married Jane Doe 1 when she was 15 years old because she was pregnant and he wanted to protect by law if they were married. He apparently believed the spousal privilege would preclude Jane Doe 1 from testifying against him. The evidence also not bear a rule of 403 that the defendant argues. Okay. Let me see. I think it's supposed to be Jane Doe number 2 because see how they missing the words? Jane Doe number 2 will potentially be part of Mr. Kelly's trial. The defense was blindsided, yet it is difficult to comprehend for what other purpose the government would have provided 35 material to both John Doe and John Doe 2, other than provide the defendant the statement, including their respectful statement regarding the sexual contact between the defendant and each of them, related to the evidence of the government intended to elicit at trial. Notably, the evidence and statement produced in the defendant.
Hold up. Could you get the likes up because it got a whole bunch of haters up in here? Sorry.
Yeah, we do. We need more likes. We need more likes. Pause.
Y'all up in here trying to get
pause,
information. Get the likes up.
We got 126 likes and 15 dislikes, but 188. So 126 and 15.
No, we got
that's
191
still
in here right now.
The information is watermarked anyway.
No, but the point is,
it don't matter. We still need likes. Still. So that's only 141. Sylvia, that's only 141. So we need 50 times 50 people watching. 50 people are watching with no likes. So we need 150 total, which is 24 more likes.
Brandon, stop.
We need 24 more likes before she continues.
Brandon, stop.
Well, I'm trying to get you the likes.
Put that music down.
You're not on the side for this.
We need for real. We need 24 more likes. So
I'm talking about Sylvia and Randa.
That'll bring us to 150 likes. Come on, guys.
Okay.
There's a 194.
Reading Rainbow Randa. Or am I doing a good job so far?
Randa about to be pissed.
Okay, number 3. Do I still got continue or wait?
Wait.
Hold on. Let's see how many likes. Hold on.
It's almost 200 people up in here trying to get free information.
We got 142. We need 8 more likes, y'all. 8 more likes to 150.
No,
and then
it's we got 195 in the chat now.
So that'd be 150 and 22. That's 177. So then we'll be short 20. So we need 20 more likes. 20 more, y'all. 20 more likes.
You can go 15 down.
She said we need 20 more. 20 more.
Likes up, y'all.
Come on, y'all. That's the least we could do. 20 more, guys. So we're at
313 still awake, y'all. He is still awake.
we at
313 is awake?
143.
Yeah.
I mean, I'm not supposed to be disrespectful and cut the reader off like,
Disrespect on mine going to sleep.
huh?
Man, you do this
Sound like
every
his voice
time.
is going to sleep.
Nah, man. I had my
Take that
medicine.
look.
I'm up.
Feeling good with your medicine, huh?
Yes, ma'am.
He said, yes, ma'am. So what's the lights like, Troy? I'm gonna beat the crap out of Rand in a minute.
We
Hey,
have
Randa,
146.
Everybody, a million.
Hold on, y'all. We have
Hey, Randa.
146 and 24 dislikes. Come on,
All right,
y'all.
back on the show.
146.
Randa, they not gonna get their millions.
They ain't gonna get that shit. I don't
So
know
we
where the
need
hell he thought he was gonna get that shit at.
What?
Ooh.
We gonna get it from
So-
you, Randa. You better
No,
go
we
out.
need 4
They
more.
have the county said that they get.
4
You
more
gonna be
likes,
selling a
y'all.
whole lot of cootie cat to get $8 million.
Ooh,
4 more likes.
shit, me and Dom got 40.
We need 4 more likes.
Yeah. Hey, I need that. I need that.
Y'all, I hate all of y'all right now.
What was it, Randa?
Randa, you gonna be working your ass off because I'm gonna need a couple $1 million.
Hey,
Though,
313.
Randa, for
Because you
real.
just did that. Hey, 313. Because you just did that, they're gonna say you swing that way.
I need 2 million, Randa. I
Well,
need 2 million.
2 million.
Damn.
Shit.
Y'all trying to clear her pockets out. Yeah.
What?
At
I'm
least
gonna pay her
Fire
back once
being
my
generous.
business
I
plan go
heard
through in like 5 years.
I
How
asked
many
for
we
one.
have now?
That's
that
it.
was a
Jessica, how
a
many we have?
generous. That was a
Y'all
generous
we have
offer.
hold on.
funny right
We-
now. Y'all
Hold
hella
on.
funny.
We're at 150. Continue spitting fire. We're at 150 now.
Okay,
so
number
let's go
3.
at it.
No believe the evidence and statement produced to the defendant pursuant to Rule 16 from the inception of the government prosecution, as well as his initial statement produced pursuant to 18 U.S.C. 35, all prior to the finalization of the jury questionnaire, including multiple choice allegation concerning same-sex contact between women and the girls at the defendant's direction. The defendant, however, at no point requested that the potential juror be questioned regarding their views on same-sex relationship or sexual activity. The defendant's exertion of the severe prejudice as a bias to exclude the evidence related to John Doe number 1 and John Doe number 2, therefore, ring hollow and appears to be a pretense aimed purely to excluding clearly evidence of the charge racketeering activity, particularly where, as noted above, the potential jurors viewed on this subject may really be probed during a jury selection. Given at the nature of the allegation is similar to other allegations contained in the indictment, including that the defendant had sexual contact with Jane Doe number 4 when she was just 16 years old. In the event, while the evidence of the defendant's sexual contact, Jane Doe number 1, may be presidential, it is not unfairly so. The contrary is seemingly probative of the reason into which the defendant engaged in the alleged bribery scheme in the first place. Finally, the defendant's claim that he does not know the identities of Jane Doe number 7 and Jane Doe number 20, John Doe number 1 and John Doe number 2 simply falls flat. First, in its 35 material and Rule 16 disclosure, the government has provided a full identity of several of these individuals as provided sufficiently detail about them that it is difficult to fathom that the defendant is his counsel do not readily know many of their identities. Even assuming that the defendant does know most of their identity, assumption that the government finding difficult to credit the government's provided detailed description of their allegations and other defendants in its initial production of 35 material, giving the defendants more than sufficient opportunity to prepare for its defense. Moreover, upon receiving the defense opposition motion, the government has now also provided a list of identities in the defendant. Notably, at the time, did not the defense ask their identities. Had they asked, the government would have readily provided their names. when
they
the
admit
defense
they didn't
requests
get.
the
So they
identities.
admit it. Sorry, y'all. But so they admitting that they didn't give it to them then, huh? The
Well,
identities. Because
well,
she said they'll give it to them now. Okay.
well, they give it to them now, and they didn't ask for it and stuff like that, and all that other stuff. But then they're saying that it was in the 35 discovery. But if it was in the 3500 discovery that they trying to be in production, then why would you need to ask the court permission to have them non-charged be a witness in this? This doesn't make any sense. I forgot what the
So
fuck
what
I was
happened?
at.
What happens? Spitfire.
What I'm saying is, if they had the 500, okay, let me read that part for him. Finally, I'm going back up. Finally, the defendant claimed that he does not know the identities of Jane Doe number 7 and Jane Doe number 20, or John Doe number 1 and John Doe number 2. Similarly, falls flat. First, in its 35 material and Rule 16 disclosure, the government has provided a full identity of several of these individuals, as has provided sufficient detail about them that it is difficult to fathom that the defendant and his counsel did not readily know many of their identities. Even assuming that the defendant does not know most of their identities, an assumption the government finds difficult to credit. The government provides detailed description of their allegations against the defendant in its initial production of 3,500 materials, giving the defendants more than sufficient opportunity to prepare its defense. Moreover, upon receiving a defense opposition motion, the government has now also provided a list of identities to the defendant. Notably, at no time did the defense ask for their identities. Had they asked, the government would have readily provided their names when the defense requests their identities to Jane Doe number 2, Jane Doe number 3. Furthermore, that wasn't even the issue. Jane Doe number 2 and Jane Doe number 3. They was talking about
the funny thing is they said we gave it, but if you need it, here it is. Well, but if you
they weren't talking about Jane Doe number 2 and 3. They was talking about the John Doe's number 1, 2, and the ones from after 6 through 19.
Yeah.
So I don't understand why you put Jane Doe 2 and 3 in it. Furthermore, the government did not provide the names of Jane Doe number 1 and the names of lawyers representing many of the individuals discussing in the government's motion. Other acts evidence in a letter to the defense counsel dated February 5th, 2021, upon production of the initial 35 material, further showing that at no time was the government intended to conceal their identities. You a damn lie. For that reason set forth above in this initial memorandum, the government respectfully admits its motion should be granted. Okay, and this was Jacqueline, whoever her name, Claus, List, whatever. So, but that's not the issue of Jane Doe 2 and 3. The issue is not Jane Doe 2 and 3. The issue is the John Doe's 1 and 2 and the uncharged ones. Jane Doe 1 and 2 is the ones that's actually charged, right?
2 through to 6 was charged. Yeah.
No, it's 1 through 6.
So why do
1 through 6?
But so they saying notably at no time did the defense ask for their identity, as the government will readily provide the names when the defense requests the identity. Okay, when they request the identity.
Look, they said we gave it to you, but here is the name if you need it. That doesn't
right.
No, you're supposed to give the names. You supposed when they say give you everything, you're supposed to give the names.
Back in February,
they said we gave it to you, but if you need it, we'll give it to you.
Right. We gave it to you, but we didn't give you the names because you ain't asked for the names. You supposed to give the names.
But we gave you descriptions of
so
the
they
identity.
said when you asked for Jane Doe number 2 and 3, you could have asked for the rest of them. That doesn't make if that's the case, then why is you asking for them to be added to this goddamn
Spitfire? And I'm not sure if you caught it earlier, but Sharon Wincap says she knows so much, but she said earlier that R. Kelly does know John Doe 1 and 2. They were helping him out or whatever. They were groupies, whatever, helping him out with unloading his bus and whatnot. So if you knew R. Kelly, you would know that right now they just said that he does not know them. So it's like, how are you speaking on this man?
There's
and he said,
one, y'all. They
Come on
posted
now.
another one. Hold on.
Come on now. Exactly. I think that's going to be very difficult to prove, Miss Texas Bama. That's going to be
And then,
very hard
and
to
then
prove.
they taking the word of a liar.
Right.
All right, you ready, Dom, to read yours?
Yeah. Part 2, right?
Hold on, let me get rid of this one.
Make sure you refresh it if you pull up another screen, because sometimes it come crumble. Why Randa think I need reading rainbow?
Hey, I told you 313 would
I passed the
disappear.
third grade. I may not
313
have passed the
disappeared.
5th grade, but I passed the 3rd grade.
313 disappeared. We knew it.
I told
Right
you,
on
I told him
schedule.
that, and Randa better not have disappeared either. Where'd she go?
She right there.
She snoring. She over there snoring.
Ain't
Y'all know
nobody
Randa.
snoring, ninja. Stop talking about a reading rainbow.
Jessica, leave me alone.
Take a look.
It's in a book.
You ready, Dom?
And I am sleepy too.
Yeah. You just woke up.
And I'm
Dom,
ready to go
come
back
on.
to sleep.
Y'all playing too
Okay.
much. Come on.
Okay, here we go. This is the public redacted version of the to be filed under seal Eastern District, Honorable and M. Donnelly. This is the
We
United
ain't
States
doing all
versus.
that. Just start with that,
Yep.
dear Judge
Dear
Donnelly.
Judge Donnelly, dear Judge Donnelly, I like to read it in 30, okay? Dear Judge Donnelly, the government respectfully submits this reply to the defendant's memorandum of law in opposition to the government's July 23rd, 2021 motion in limine to admit certain evidence and preclude other evidence and arguments at trial. Hereinafter, defendant opposition, I guess. For the reasons stated herein and in the government's original memorandum, the motion should be granted. 1. Evidence regarding victims' sexual behavior with anyone other than the defendant and others at his direction should not be admitted. The defendant's response to the government's motion to preclude cross-examination or the introduction of evidence regarding victims' sexual behavior with anyone other than the defendant or others at his direction is nonsensical, makes no effort to comply with the requirements of federal or evidence 412, and contradicts the very reasons for the rule's existence. First, to be clear, the government does not seek to preclude or limit cross-examination or evidence regarding the victim's sexual interactions with the defendant or with others at the defendant's direction. See defense opposition at 1. The government has failed to provide any justification for excluding evidence of the witness's sexual conduct during the charged period, whether with the defendant or others. The government will elicit information from victims regarding sexual acts with the defendant and, where applicable, with others at the defendant's direction. The defendant may, of course, cross-examine the victims as to such testimony. This does not mean, however, that he may stray into areas barred by Rule 412A. United States versus Thompson, 178. Indeed, proving cases involving sexual misconduct necessarily requires the government to introduce evidence of the sexual behavior underlying crimes charged in the indictment. If the introduction of that evidence opened the door to the introduction of other sexual behavior evidence, Rule 412A would serve no purpose. Second, while the defendant claims that his opposition is submitted per Rule 412C1, noticing the intent of the defense to elicit certain relevant evidence. ID at 2, he fails to comply with that rule. Rule 412 requires that if a party intends to offer evidence under 412B, the party must A, file a motion that specifically describes the evidence and states the purpose for which it is to be offered. B, Do so at least 14 days before trial, unless the court, for a good cause, sets a different time. C. Serve the motion on all parties. D. Notify the victim or, when appropriate, the victim's guardian or representative. Federal R Evidence 412C1 emphasis added. The defendant provides no such specific description. C. Defendant opposition at 2, indicating without any valid explanation that at this time the defense cannot catalog specific facts we intend to elicit. Instead, the defendant simply asserts that unspecified evidence of unspecified victims' sexual predisposition and behavior with other unrelated to the defendant is somehow relevant because some of the charges allege some form of coercion and or force of the defendant's part. Defense opposition at 1, by its terms, however, Rule 412 applies to criminal proceedings involving alleged sexual misconduct, including those involving allegations of coercion and force. Federal R Evidence 412A, conclusory assertions that victims will purportedly open the door to such cross-examination and evidence in their direct testimony, defense opposition at 2, do not negate or alter the requirement that the defendant comply with Rule 412. Indeed, the unspecified general evidence that the defendant apparently seeks to admit regarding victims' sexual histories is precisely the sort of evidence that Rule 412 was designed to preclude. As the Second Circuit has made clear, the very purpose of Rule 412 is to preclude defendants from arguing that because the victim previously consented to have sex, her claims of coercion should not be believed. United States versus Rivera 799 F9. Nor does the exclusion of such unspecified evidence violate the defendant's constitutional rights. Although a criminal defendant has a right to present his version of the facts to the jury so it may decide where the truth lies, it does not follow that a criminal defendant has a right to offer evidence that is relevant to the government's charges. Thompson 178 F, internal quotation mark, omitted. Evidence that a victim has engaged in sexual acts with others unrelated to the defendant does not make it more or less probable that the defendant used force or coercion to engage in sexual acts with any particular victim. CF Taylor 178. Whether the victims engage in acts of prostitution before or after their alleged encounters with the defendant would only prove other people may be guilty of similar offenses of recruiting, enticing, or causing these victims to engage in a commercial sex act. That's crazy. Nor has the defendant explained how a specific victim's sexual history is relevant to any alleged bias or credibility of that victim, while the confrontation clause guarantees a criminal defendant the right to cross-examine government witnesses at trial. United States versus Figueroa 548. Trial judges nonetheless retain wide latitude insofar as the confrontation clause is concerned to impose reasonable limits on such cross-examination based on concerns about, among other things, harassment, prejudice, confusion of the issues, the witness's safety, or interrogation that is repetitive or only marginally relevant. Delaware versus Van Arsdale 475. In this way, the confrontation clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defense might wish. Delaware versus Finsterer 474. Exclusion of cross-examination regarding irrelevant sexual acts does not violate a defendant's Sixth Amendment right to confront witnesses at trial. Rivera 799. Finding preclusion at finding preclusion of cross-examination as to irrelevant prior acts of commercial sex did not violate defendant's confrontation clause rights. United States versus Cephas, 684. Finding exclusion of cross-examination of victim witness regarding prior acts of prostitution did not violate the confrontation clause because the evidence was irrelevant to the charged sexual misconduct. United States versus Valenzuela, 495. United States versus Overton, 2017. Finding evidence of acts of prostitution outside the indictment's time period were irrelevant to the charged conduct, and therefore Rule 412 exclusion did not violate confrontation clause. Thompson, 178. Any alleged unchastity of a victim has no relevance whatsoever to the victim's credibility as a witness. That's cap, but that's just me. The defendant has made no attempt to specify what purported sexual behavior or sexual predisposition he intends to elicit or cross-examine witnesses on, or coherently explain how such evidence is relevant. Indeed, he does not even specify which witnesses he intends to cross-examine about such matters. In these circumstances, the government's motion should be granted. Part 2. The government does not seek to admit evidence of religious beliefs or experiences. As the court is aware, the government moved to preclude the defendant from cross-examining witness number 1 regarding his religious beliefs or experiences described in a book published by witness 1 in 2011. In his opposition, the defendant has apparently misconstrued the government's motion as one that seeks admission of testimony from witness number 1 regarding his religious experiences and the defendant sounding, quote, demonic. The government has no intention of eliciting any such testimony. As a result, the defendant should be precluded from cross-examining witness number 1 regarding these matters for the reasons set forth in the government's motion. Part 3. The defendant should not be permitted to reference prior psychological histories. That's completely blocked out. Part 4. The defendant should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of certain victims. The government moved to preclude cross-examination and introduction of evidence or argument that parents of any victims consented to the defendants having sex with those victims while they were underage. The defendant appears to concede that any such alleged consent is not a defense to the charges. Instead, he argues that the conduct of the parents in allegedly seeking to profit from or extort the defendant is relevant because presumably the government intends to elicit testimony from the witnesses regarding a lack of access to their parents or the concern that the parents demonstrated for the witnesses or actions that the parents made to connect to a child, rather. The government does not intend to elicit from its witnesses any testimony regarding their parents' concerns for them or actions the parents took to connect with their children. The government will, however, elicit testimony regarding the defendant's efforts to monitor and otherwise limit Jane Doe number 5's communications with her parents, which is BS. She said she contacts him anyway. Such testimony regarding the defendant's actions does not render the conduct of any parent of a victim legally.
This is when they need that precedent to show him to that. You remember?
Exactly. They need that video clip where she said, any city we went to, R. Kelly made me, or Robert made me contact my parents. Is this your dad's number? Okay.
And I did not want to contact my
exactly.
parents.
Exactly.
she
So
Y'all, we don't want to say too much, so the
Right.
defendants, the prosecutors, who listen to this,
Exactly.
they can know what y'all going
Oh,
to say.
am I back on here?
Yeah, so
This is
don't
put
say
down. This is put down.
what they should do, y'all.
okay, I'm gonna continue. You cap. Okay, that's cool. But I'm not the lawyer. Anyway, they can hire me.
The Donald's
Now
motherfucking reading crazy.
that's what's up. They can hire me. But anyway,
Nigga, you
such
can't read.
testimony. Okay, such testimony regarding the defendant's actions does not render the conduct of any parent of a victim legally relevant to the charges at issue. As a result, the motion should be granted. Part 5. Evidence regarding specific instances of the defendant's good conduct should be precluded. In opposing what?
Sorry.
In opposing the government's motion to preclude the admission in evidence of prior instances of the defendant's good conduct, including awards and honors received in connection with his career as an entertainer, the defendant mischaracterizes the breadth of the government's motion. Contrary to the defendant's assertions, the government does not seek to preclude background testimony by the defendant should he choose to testify regarding his employment or personal circumstances.
Do you know what? This is kind of biased, what they're trying to stop him to show the good side of a person. What? Oh my God. That's what they always do in any case. They always
Keep reading down. Sylvia just trying to stop you. Go ahead.
No, I need the numbers up. It's two more people came in.
Oh my goodness, Sylvia, really?
Oh my goodness.
Look, I say oh my goodness all the time, but I'm just saying. They're gonna say you starting to sound like a fanatic. Somebody get them likes up.
That's right. I'm gonna be a fanatic. It's my channel. If I want the numbers up, I want my numbers up. Period.
Okay, let me know when you're ready.
Hold on. Let me look at the numbers. Hold on.
I can't see the numbers.
And you know what else, Sylvia?
Hmm?
I'm not trying to be mean. I don't give a damn what nobody else say, but you need a minimum. You need a minimum amount before you start putting these motions and everything up on your page, because they can get this from somebody else. You know, nobody else putting it up like this.
They not.
You know what I mean? Not like this anyway, because you putting up the defense and you putting up with the defense and the prosecution, and that's a lot of money. Whereas other people just put the side up that they are supporting. You get what I'm saying? So until you start not only getting likes up, but you need a minimum, because there's so many people in your chat and there's so many people in your channel that 99 cents or whatever is not hard to come by to get all this free information that they've been getting for over a year.
Yep.
Okay, so if they don't put the likes up and they don't give you a minimum, they don't get it. You could just talk about it or whatever, what you read, and that's it. They don't get to see it for themselves, because it's not, for one thing, it's unappreciative, it's not right. You know what I'm saying? And it's taking things for granted. And these are supposed to be what we call supporters.
What up? I ain't seen you in a minute.
These are supposed to be supporters. And if you are a supporter, we shouldn't have to say donate to the channel. Even if it's 99 cents, if you got 100 people in here, they can donate 99 cents just to make sure they cover your Pacer account. You shouldn't have to do that. Then you go and pay your money to go to the trial to report back to them. And it's not like someone helping you pay for your flight. It's all out of your own pocket.
Well, one person did help me pay for my flight, Lavelle.
Yeah, but what I'm saying, that's what I'm saying.
Yeah, that's true.
That's what I'm saying. Like, if we're supporters, you're supposed to support the people who actually doing the work and giving you the breakdown.
Thank you, Raquel. She gave me my 99 cents. Yay.
That's right. You're supposed to. Thank you. Because it's not going to hurt nobody. You know what I'm saying?
Okay, guys, We're at 189. Can we just get to 200 likes? That's it. That's 11 more.
It's not your channel, Dom.
Okay, here we go.
Nah, Dom, I want the 200.
Here we go. No, you're right. It's cool. Where was I at?
Ron, Dom, I do want the 200.
Well, how about we get that after I read?
No,
You know what I'm saying?
you ain't gotta read.
Well, you at Dom. I'll finish it if you want me to.
No, I mean it's like
No,
I
she's
want
saying
the
I
200.
can't because the likes, but I'm gonna continue.
I'm gonna be selfish just like they's being selfish. I don't care what nobody think. Shoot.
I take it down until you can get your likes up and you can get a little bit more of your minimum. There you go. That's how you do it. That's it.
Y'all
That's
crazy.
it.
Y'all crazy.
I mean, I'm serious because
Come on
that's
now.
why I don't give. That's why I don't do it because people don't support. Like I got enough of that when I was starting my initiative, and I'm fighting and trying to do all this, and they wanted me to do it, and I wasn't getting the support. We're the only culture that do that. You know, black people, white people, when they want something, they support. We the only culture that has a problem with pulling teeth to get people to do right. So they don't get it. We can just talk about it like we've been doing. So
Take a look at the book, A Reading Rainbow.
So what do you? But see, you know, you need to Reading Rainbow. I know I went to a Detroit public schools, Dom. Okay, but we were low.
I
on
wasn't
funding.
talking about you, Spitfire.
But I did step my game up when I refreshed my computer.
Oh my goodness! Now I feel you.
Did I not step my game up, Sylvia?
Yeah,
You did.
I
Yeah, you did. For
I
sure.
stepped my game up when I refreshed because the words wasn't coming in right. I said, "What the heck?" I said, oh, "Okay, it wasn't finished downloading. I'm sorry."
Nah, for sure.
You know how sometimes
How many we at now?
They went and took it down from the positive. They took it to the negative.
Hey,
Yeah, they mad. They
180.
mad.
I'm gonna just continue. F it.
Thank you.
We don't
Put
want
it on
to
the
do-
table.
Thank you so much. It's the
Thank you.
right thing to do because it's not free.
There's more numbers coming in. There's more of them coming inside the chat too. The numbers going
B
up.
Rock,
in the
you
chat.
stupid.
But see, the thing is, nobody else is doing it right now, so they came in here.
Well, they can go.
No comment. It's not my channel.
Randa, what you doing? You better not be asleep.
I am not asleep.
I know you doing something bad. What are you doing?
I'm cleaning up.
Mm-hmm. Sure you is.
She's trying to figure out a way to cuss out the teacher.
Nah, I can't play my music no more.
Oh, the Reading Rainbow.
Yeah,
I knew you was gonna be
sick.
sick.
Every time I play that shit.
She mean it. You said why you?
Well, you should have played that Reading Rainbow when Dom K was reading.
She wouldn't let me back on. I got kicked off.
Yo, Brenda, all I heard was when you tried to say why you and
How you get kicked off your? How you get kicked
I don't
off,
even
Randa,
know. I
on
don't
the
I
even
said she
know.
about to be
side
hot.
and support?
She did give me some of that 8 million.
Apparently.
Randa, how do you get kicked off on people who you support? Now
Right. And then
Hey, look at it.
look, she don't even be looking at the damn backstage. I'm sitting there forever.
Yo, we really at 185.
She don't look backstage. She really
Oh,
don't.
look,
The
they
other
put
day-
it back down. I'm gonna go, y'all. You're gonna.
They
I'm
took 2 more back. Come on, y'all. For
No, they
real.
went down. They
What
put
do
it all on the negative.
I don't beg nobody
Yeah.
to sit up there and read it now.
Y'all,
Come
we
on,
got
that's
3 more
ridiculous.
pages. We got 3 more pages. Come
But
on, y'all.
Stevie, you also got to think about the people that actually like and donate to the channel. So
This is like the good part too. This is getting good.
Oh, well, if it's the people that
you
donate
making
to
the
the
people
channel, you
suffer
can
that
always.
actually
You
like
gotta
it.
donate. Well,
You're
listen,
making the
what?
people suffer that actually like your channel and donated.
Well,
but
if the people
donation,
like
the
it,
people
then
that
you
like
can
my
sit up there and
channel, not
add
that
them
many,
in here,
Randa.
and you can read it to them, and they can know what's going on. The ones that donated, because you can count on your hand which ones that donated.
Yeah.
So you can just hit the link. You can keep yourself
That's
anonymous.
terrible.
And
Y'all
you can
going
read.
crazy. Yeah, y'all crazy.
No, we're not crazy. We're just being fair. Come on now.
This
All I
ain't
asked was
channel.
for
It ain't
likes.
mine.
All I asked was
Yeah,
for
it's yours.
likes. That's
It's
all I
yours.
asked.
It's
I didn't
yours.
ask for no money. I asked for likes.
I
Well,
feel you.
I asked for the money because I'm cheap. I ain't spending my goddamn money.
Come on, y'all, for real. At least the people who dislike just hit the like to 200. It's only 10 more likes, and then that way I can finish
All
the
they gonna
reading,
do is hit the like, and then when she done, they gonna hit the
then take it
dislike.
back. Yeah, well,
That's
at
They
least
okay.
do
do
it all
that.
the time. They
Look,
do it
hey,
all the
we can
time.
all let's do this. We can end this now, and then we don't have to worry about them hitting the
So we
likes
don't
and
do that.
dislikes. I mean, it don't matter.
Night,
Butter,
Carol.
Butterflying is just
Good night,
donated
Carolyn.
for
Come on, guys, for real. This is important. If y'all, how about this? You don't even gotta like Sylvia. If you like R. Kelly, hit the like button. Shit.
Shannon Lewis says I just donated.
Honestly, it's just a
Hey,
like.
Shannon. Huh? But you know what? This is the last time. I'm not doing it no more. Okay, well,
Okay.
go ahead and
Read
read
it,
it.
just read it, and that's
Go
it.
ahead,
So here
read
we
it.
go.
That's it. They'll never get me to read nothing again. That's it. That's all there is to it. Go ahead.
So here we go, guys.
I'm
Part
just
5.
done. I'm done.
Evidence regarding specific instances of the defendant's good conduct should be precluded. In opposing the government's motion to preclude the admission in evidence of prior instances of the defendant's good conduct includes awards and honors received in connection with his career as an entertainer. The defendant mischaracterizes the breadth of the government's motion. Contrary to the defendant's assertions, the the government does not seek to preclude background testimony by the defendant should he choose to testify regarding his employment or personal circumstances. Nor does the government seek to preclude the defendant from offering evidence of the defendant's pertinent character trait pursuant to federal rule evidence 404A2A. Instead, the government's motion relates to the manner in which such evidence may be admitted and seeks to preclude the admission of evidence regarding specific instances of the defendant's prior good conduct. Example, i.e., specific prior good acts, such as testimony or evidence regarding specific awards or honors received in the course of the defendant's career or employment, or specific acts of charity. Wow. Rule 405 specifically sets forth the manner in which a person's character or character trait, where admissible, may be proved and limits the manner of proof to testimony about the person's reputation or by testimony in the form of an opinion. Federal Rule Evidence 405A. Rule 405B further makes clear that evidence of relevant specific instances of a person's conduct may only be used to prove a person's character or character trait when the character or character trait is an essential element of a charge. Federal Rule Evidence 405B. Put simply, the defendant's character or character trait is not an essential element of any of the charged crimes. What? As a result, the only permissible manner in which he may prove a pertinent character trait is pursuant to Rule 405A by reputation or opinion testimony, not specific prior good acts. See United States versus Doyle 130F. Proof of defendant's specific acts inadmissible under Rule 405B because character was not an element of any of the charged crimes. The defendant's reliance on United States versus Han 230F is therefore inapposite. While affirming the conviction in Han, the Second Circuit found harmless error in the district court's exclusion of testimony as to the defendant's reputation as a law-abiding citizen who does not exploit others. Similarly, the character evidence at issue in United States versus Pujana Mina consisted of testimony about the defendant's reputation in his community as an honest and law-abiding person, not any specific prior good acts. Evidence of such specific prior good conduct should be precluded. Part 6. Evidence regarding Jane Doe 8's subsequent employment is irrelevant. In his opposition, the defendant makes absolutely no showing that Jane Doe 8's employment as an exotic dancer years after the defendant had sexual intercourse with her when she was 17 years old is at all relevant, nor could he. Instead, he simply states, without any explanation, that her subsequent employment is, quote, is admissible for proving motive, opportunity, intent, preparation, plan, knowledge, identity, absent of mistake, or lack of accident. Absent any showing of relevance, the government's motion should be granted. Part 7. Certain text messages by Jane Doe 5 and relating to Jane Doe 5 should be admitted. The defendant summarily asserts that from a plain reading of the text messages the government seeks to admit, the messages would open the door to the very same evidence that the government is attempting to preclude, and asks that the court allow the defense latitude in cross-examination to explore the many topics included in the text messages, such as sexual behavior, psychological issues, and certain actions of witnesses' parents. In so saying, the government assumes that the defendant is referring to the text messages between Jane Doe 5 and Jane Doe 5's mother, and not other text messages the government seeks to admit. Even if so, the defendant has not explained and cannot explain how those text messages open any door to cross-examination. Rather, the text messages show only that Jane Doe 5, number 5, recounted to her mother nearly in real-time statements of the defendant, as Jane Doe number 5 will testify. The defendant suggests that prior consistent statements are admissible only to rebut a recent motive of fabrication and not simply to rehabilitate a witness. He is wrong. As an initial matter, he ignores that prior consistent statements are expressly permitted to rebut an express or implied charge that the declarant acted from a recent improper influence or motive in so testifying. Federal Rule Evidence 801D. Moreover, the defendant neglects to mention that Rule 801D-B was amended in 2014, expressly permitting prior consistent statements for the purpose of rehabilitation where a witness's credibility was attacked, adding that prior consistent statements are admissible to rehabilitate the declarant's credibility as a witness when attacked on another ground, and therefore that the case law cited by the defendant all before the amendment is in apposite. Part 8. The court should admit Jane Doe 5's electronic note. The government seeks to admit an electronic note written by Jane Doe 5 on August 30th, 2018 that contains the defendant's statements to her. See motion at 3435. Jane Doe number 5 will testify regarding the circumstances of those statements and the note. As indicated in the motion, the defendant's statements as contained in the note are highly probative of the defendant's commission of the forced labor offense as to Jane Doe number 5. The value of such highly probative evidence is not substantially outweighed by a danger of unfair value. Is not substantially outweighed by a danger of unfair prejudice. See Federal Rule Evidence 403. Indeed, it is direct evidence of the crime. See United States versus Curley 639, noting that for evidence to be unfairly prejudicial under Rule 403, it must tend to have some adverse effect upon a defendant beyond tending to prove that the fact or issue that justified its admission into evidence. Part 9. The admission of certain newspaper articles is warranted under Rule 803.16. As clearly set forth in its motion, the government seeks to admit newspaper articles from 1994 for the following purposes: to show that 1. The defendant performed in Macon, Georgia on August 30th, 1994, in Albany, Georgia on August 31, 1994, and in Miami, Florida on September 2nd, 1994. And 2, witness number 1 was in fact the defendant's tour manager on August 31, 1994. There is nothing circular or confusing about the intended use of such articles. Such evidence is relevant for the reasons stated in the government's motion and is admissible pursuant to Federal Rule Evidence 803.16 and 902.6. 10. The sealing. The government requests that the court permit the government to file both a sealed and a redacted public version of this motion. The redacted version will redact certain content from the publicly filed version of this motion that details medical and other private matters of certain witnesses. See United States versus Amodeo 71 F3D. Privacy interests of third parties may be compelling reason justifying sealing. 11. Conclusion. For the reasons set forth above and in the government's July 23rd, 2021 memorandum, the government's motion in limine should be granted. Respectfully submitted, Jacqueline M. Kasulis, acting United States Attorney. Yep. So that's it. That's crazy. Hello? Are you guys there? Hello, hello, hello. Wow.
All right, Dom, I'm about to go. Okay. Dom?
Okay.
Dom?
I'm here.
Thank you guys for those who's been diligent and supporters of this channel, but I have made a decision. I'm not doing this anymore. I'm not reading this stuff anymore. I'm not doing this. Got 251 people in this chat, and I'm done.
Don't be discouraged, Sylvia. It's all good. I said, don't be discouraged.
I'll send you stuff for tomorrow, but I'm done. And those that rocks with me most of the time, send me an email. I'll just get you guys those things from now on. Because I'm not doing this no more.
You got 200 likes and 50 dislikes. You have 245 in the chat. That's
okay.
good. That's good.
No, that's not good for me because I had to pull teeth to do this. So I don't want to do it no more because that's lack of appreciation. You're welcome, Friends of Tech, but I'm going to go, y'all.
I appreciate it. Just make sure you.
Good night, everybody.
You guys have a great night. Be blessed.